Not surprisingly, this mother does not claim to be perfect. She made some bad choices in relationships early on in her life that have caused her and her family a lot of grief. But she was over that by the time the things outlined happened, and then, unfortunately for her, some people on a mission smashed into her life and wrecked it and her family again. Bradford is on such a mission, and if she succeeds, will be responsible for laying waste large numbers of good New Zealand families. Maybe your family will be one of them. I would like to think Sue Bradford is sincere, but I can't bring myself to do so. I can't because while she rants on in cliches about child abuse and the culture of violence in New Zealand, she has not shown the slightest interest in stopping the mass murder of the unborn in New Zealand, which is the ultimate in child abuse. This puts the lie to her sincerity and indicates another agenda, one clearly shared by her fellow Greens and the Labour Party. So, if Section 59 is removed, this mother's story could be in the future your story, the story of your family. Certainly not every family will be wrecked, but emphatically some will be, and yours could be one of them. The only way all families will be safe and for parents' rights to correct their children protected, as Section 59 protects them now, is for Bradford's bill to be defeated. Let's hear in her own words what Sue Bradford says about this case and what she intends for similar cases. You make up your own mind as to whether you want Sue Bradford to have anything to do with the raising of your kids and whether she is at all qualified to do so. Because if her bill goes through, she will have kicked her way into your home telling you how you should and shouldn't raise your kids.
Well, I will use just the case that has already been referred to because it's probably the most famous case in New Zealand at the moment, though there have been others. And that is the case of the Timaru woman who was let off charges of assaulting her son by a jury after she had beaten him with a horse crop and a cane on several different occasions. That jury decided not to convict. That was the choice of that jury, and that was within the law of New Zealand. And I say it because that is the law I want to change. That was the jury's right. It was the woman's right to have a lawyer who got her off. So I'm not saying that she was acting within the law of New Zealand because that jury accepted that her beating her son in that way on different occasions with the horse crop and the cane was reasonable force given the circumstances. A jury of her peers made that decision. What I'm trying to do is to change the law that allowed her to have that defence.
Yes, thank you for the opportunity to respond here. As Sue Bradford pointed out, the number of cases of Section 59 even being raised as a defense are very rare. I have here a study by lawyer John Hancock, who works for the Action for Children and Youth Aotearoa anti-Section 59 crowd, and he was doing a report for the United Nations Committee on the Rights of the Child, the group that polices all those countries who have signed the convention and are looking to see how we are getting rid of these kinds of laws. And he could only find 18 cases of where Section 59 was brought up. Some of these weren't even in the criminal court. Some of these were in the family courts over a 13-year period, which ended in 2002. And out of those 18 cases, that's about 1.4 times a year. It's rarely brought up. More than half of those, the parent was found guilty. The parent or caregiver was found guilty. So Section 59 works brilliantly. It nails the abuser. Now, in this case of the Timaru lady, as I say, her lawyer didn't get her off. He let the other lawyer do all the talking. And it was just obvious. The child submitted. Now, I have to disagree with Sue here. He was not beaten. Now, in Sue's eyes, perhaps he was beaten, but the jury didn't think he was beaten. He was 2 smacks with a riding crop, and that was for swinging a baseball bat at his dad's head. And he got 6 strokes with a little 18-inch garden stake. Again, he submitted to that happily because he kicked in the door at the school, and the school couldn't believe the change in this boy's. He was just a new kid, and so it was just wonderful. The problem was over. There had been a family reconciliation. I mean, you know, I've talked to this woman. My wife sat and had a meal with her. We've had a bit of communication with her. And as I say, Section 59 already does the things that Peter Dunn was hoping that it would do. It defines what reasonable force is. You can only define reasonable force when you have a context, when you know what the crime was, when you know all about the child, when you know all about the caregiver, when you know all about any implements, when you know about extenuating circumstances, relative sizes, weights, forced use, the whole 9 yards. That is what makes it reasonable or not. To define, and I agree with Sue in this case, you can't define it. It's just impossible. Don't even try. But one of the biggest problems here is when people like on the pro-repeal constantly equate any kind of smacking with violence, beating. Well, these are kind of emotive words. Smacking, most parents who smack their children, they understand there's a world of difference between smacking and beating. They're just two different critters. They don't have the same motivation. They don't have the same objective. They don't have the same aim. They don't have the same methodology, and they don't have the same outcome. They're not even on the same continuum.